Good afternoon, and thank you for joining us for today's webinar. My name is Matthew Jane, and I am the Museum Education and Engagement Coordinator for the State Historical Museum of Iowa. The Iowa History 101 webinars, presented on the second and fourth Thursdays of each month, explore Iowa's history from pre-statehood to current day. You can learn more about this series and all of our programs on our website at history.iowa.gov. Please remember to sign up for each webinar you would like to attend, and don't worry if you can't watch live. All presentations will be recorded. Today, we'll learn about how the daughter of an enslaved woman successfully fought segregation on steamboats on the Mississippi River. Now, a few housekeeping points before I introduce our speakers. Everyone came into this webinar on mute with cameras off. Closed captions are available by clicking the closed caption button on your screen. The webinar is being recorded and will be placed on the Iowa Culture page of YouTube in just a few days. I've disabled the chat function, but if you have questions, please type them into the Q&A feature throughout the webinar. My colleague, Jess Renlet, and I are watching that feature and will prepare a list of questions for the speaker at the end of the presentation. But please note, we may not be able to get to all the questions before time runs out. Now I'm pleased to introduce our presenters, Leo Landis and Jennifer Verhein. State Curator Leo Landis has his Bachelor's of Science in History from Iowa State University and a Master of Arts in Historical Administration from Eastern Illinois University. He has completed all but his dissertation toward a PhD in history from the Iowa State University. His museum experience includes time at Living History Farms in Urbandale, Connor Prairie in Fishers, Indiana, and 8 years as curator at Henry Ford Museum in Greenfield Village in Dearborn, Michigan. He also worked as a curator and director of education at Salisbury House in Des Moines, Iowa. Jennifer Verhein currently serves as Civil Rights Specialist for the Iowa Civil Rights Commission, where she investigates and reviews complaints filed with the commission. Jennifer has her Bachelor of Arts degree from the University of Wisconsin and Juris Doctor from the University of Minnesota Law School. She has previously worked as Director of Language Access for the Nebraska Supreme Court and as Assistant University Registrar for the University of Nebraska in Lincoln, Nebraska. And now I'm happy to turn over to Leo to begin the webinar.
Well, thank you, Matt. Thank you, Jennifer. And thank you, Jess, too, for being on the back end helping out. I'm going to begin the program just talking about the framework of equality and equal treatment in Iowa. And I know a lot of folks know this case, but when you talk about equal treatment in Iowa and how the judicial branch and the Iowa Supreme Court have ruled, you need to look at the territorial period. And with the case of Ralph, which dates back to 1839 with the ruling, but Ralph was a Black man who'd been enslaved in Missouri, came to Dubuque, and was then able to try to earn enough money to purchase his freedom, which it didn't happen. And his enslaver, Jordan Montgomery, sent men to retrieve him, and people in the Dubuque area stopped that from happening. It goes to the Iowa Territorial Supreme Court, and Justice Charles Mason, writing the opinion, says, due to the Northwest Ordinance, Northwest Territory statutes applying to the Louisiana Purchase as well, slavery cannot exist in Iowa, and Ralph should go free and be a free man. So applying rights to a Black man in territorial Iowa is a pretty unique ruling, and one all Iowans should be proud of. And just to reflect on that too, these are stories that we're going to share today that really had implications for the people involved, taking some risks sometimes. And so it's with support through the judiciary that some of these cases are coming through. And so this is one, again, not every Black was treated equally in Iowa, but the Territorial Supreme Court sets up that process that Blacks in Iowa have rights from our very first Territorial Supreme Court case, ruled on July 4th, 1838. And it makes national newspaper coverage, as you can see in those two little clips that are off on the side there, talking about slavery in Iowa, that a slave taken to work in the mines and to work on his own time has been given his right to freedom. So really important territorial case. But then when you look at our debates around the Iowa Constitution and our first, at least, effort at statehood beginning in 1844, where there are territorial, or where there are debates around who has rights in the Iowa Constitution, J.C. Hall, who's listed on the far right of this slide, was from Mount Pleasant, so Henry County, and a delegate to both the 1844 and 1857 constitutional conventions. And the arrow is pointing to a section saying, "Can the Negro be admitted to those privileges and not impair the right of whites? Your committee think not. The government then would be unjust to admit them. The Negro, not being a party to the government, has no right to partake of its privileges." So the idea that Blacks in Iowa, and in this case, it's mostly going to be men, as you'll see in the next slide I bring up, aren't being represented, aren't part of the petitioners for statehood, and thus have no rights. That's what the statement is coming out of most of the Constitutional Convention in 1844 is. And there are a handful of Blacks in Iowa by 1844. Alexander Clark, I'm going to reference a little bit, is in Muscatine by that time, and he is certainly someone who had been advocating for his rights. You get to the 1857 Constitution, then the rewrite and the debates that are happening following up on the 1846 Constitution. And so I'm on the left column there, and about halfway down, talking about the framework of Blacks compared to women and infants. And the writer, again, J.C. Hall and colleague D.W. Price in this debate are saying, "The infant is not entitled to liberty or the pursuit of happiness until he arrived at the age of 21 years. Females, by the arbitrary rules of society, are excluded and debarred from many things which males consider right and high privileges, such as the elective franchise, holding office, and etc. Now, in these cases, the female and infant are denied what we abstractly term unalienable rights, and they submit without complaint or murmur. No one thinks of sympathizing with them in their deprivations. The philanthropist has never had occasion to commiserate their fate. Still, it is in those respects the same as the citizen of color. The Negro is surely no better than our wives and children. It should not excite sympathy when they desire the political rights they are deprived of." Well, that's just patently false. You've got the Seneca Falls Convention of 1848, where women are advocating for equality, and you start seeing suffrage activity, but J.C. Hall is not sympathetic to women's suffrage, women's rights, or rights for Blacks. And so going to that middle column about halfway through, this is all from the Constitutional Convention Debates, Volume 2, as the citation at the bottom of the page says, "It is the white population who are about to form a government for themselves. No Negro is represented in this convention, and no one proposes to become a member of the compact. It is the white people of this territory who petition for the admission of the Negro. They necessarily believe that the introduction of such a population as citizens would not interfere with the enjoyments of the white citizens, or they place this admission on the ground that the Negro has the arbitrary claim as based as a natural right." And so again, saying these are white men who are petitioning for a revision of the state constitution for the state government. And so since no Negro is represented, they shouldn't have rights. Well, again, Blacks in Iowa, especially Alexander Clark and his Black friends in the Muscatine area, are certainly advocating for Black equality at this time. At the same time this is happening, Clark and others are petitioning for the right for suffrage, and that's why it's being debated. And then just to wrap up on this little debate here, talking about the rights of Blacks, saying, "However, your committee may commiserate with the degraded condition of the Negroes and feel for his fate, yet they can never consent to open the doors of our beautiful state and invite him to settle our lands. The policy of other states would drive the whole Black population of the Union upon us. The ballot box would fall into their hands, and a train of evils would follow that, in the opinion of your committee, would be incalculable. The rights of persons would be less secure and private property materially impaired. The injustice to the white population would be beyond computation." So just, blatantly racist language and concern as well in a racist way about what would happen if Black suffrage were offered, that Blacks from across the Union would come to Iowa, and seeing that as a bad thing. And of course, it wouldn't have been a bad thing. It would have made our state a richer and better place. So that's the framework you see pre-Civil War. Things change a bit after the Civil War, as Black men have served on behalf of Iowa in the Civil War. They're again advocating for suffrage, and that is successful in 1868. But the case that a lot of folks know, and just to set up the framework of the Coger case that Jennifer's about to talk about, is the Clark case that begins in 1867 and is ruled on in April of 1868. And that is where Susan Clark, daughter of Alexander Clark, is wanting the family is wanting to send her to the local nearby school that is the white school. Muscatine had a segregated colored school at the time. And so that's the fall of 1867. It goes to trial in late 1867. District court rules in favor of the Clark family against the Muscatine School Board. It then in April goes to the Iowa Supreme Court and is ruled in Scott County. In Davenport is where the trial is held at the time, or the case is heard at the time. And a couple of different perspectives, and want to really get into today's full topic here in a second. But you see the Monticello newspaper uses slurs in describing Black children in that column on the center. And then the Cedar Valley Times is talking about the importance of, giving full equality to all children in the state, much like Justice Cole was the justice at the time. And the paper says, the decision of Justice Cole was that all children in the state of Iowa are equal before the law. Justice George Wright dissented from the decision, which thus affirms the decision of the district court on the ground, the Gazette says, of a technical and legal character, believing that Clark was not entitled to a writ of mandamus. So saying that even the dissent wasn't that it totally disagreed, but that it was a legal principle. And so Justice Cole writes the majority of the opinion and says Iowa cannot have legally segregated schools in our state. And of course, this is an elementary level. High school ruling is changed in 1875 with a couple of cases out of Keokuk, though Dubuque is still trying to segregate into 1876, 1877. So cases where it's Black Iowans advocating for equality. Of course, as I turn things over to Jennifer, Emma Coger's not an Iowan, but the case does get filed in Iowa, and so sets us up for looking at the next level, or the next major case in Iowa civil rights history connected to Black equality and equal treatment. And so there's your kind of framework of what's happened in Iowa up to this point. And then as the case of 1872 begins with Emma Coger, and then the ruling in 1873, Jennifer's going to give you that history.
Good afternoon, and thank you to the State Historical Society, Mr. Landis, the incredible tech support staff at the Historical Society, for welcoming the Iowa Civil Rights Commission to this sesquicentennial celebration of the Coger ruling here in Iowa. For context, this ruling came a scant 16 years after the Second Constitutional Convention in Iowa. So it's really very close in time to the constitutional framework on which Iowa was resting its laws and its structure. And Emma Coger, and we tend to overlook this because it's such a famous case, but this case was brought by a 19-year-old Black school teacher from Quincy, Illinois. She was 19 at the time of this. She had purchased a ticket on a steamboat from Keokuk, Iowa to Quincy, Illinois. And when she got onto the steamboat, she purchased a dinner ticket from a fellow passenger to dine in the whites only section of that boat. the captain saw her there. Officers of the boat saw her there. And ultimately, they forcibly removed her from the White's dining room, saying she could eat with the chambermaids or eat on deck. Emma, brave for a 19-year-old young woman, sued the company. She argued that she should be able to eat in the White dining room because she had a ticket for it. Now, this happened after she was forcibly removed, after the company argued that the dinner ticket was obtained by fraud and that she resisted with violent and rude language, and that they used, as they describe it, no greater force than necessary. And young Miss Coger won $250 in damages at trial. $250 in 1872, 1873 goes a long way. And then the Union Packet Company appealed. Next slide, please. The issue in that appeal was whether a public carrier such as this steamboat could deprive a person of equal rights and privileges based on race. That is the staggering issue that this young woman carried to the Iowa Supreme Court. And the holding in that case, which is even more stunning, is that a person of color is entitled to the same rights and privileges while traveling as a white person. So the answer was no. Public carriers cannot deny a person of equal rights and privileges based on their race. That ruling rested primarily on the 14th Amendment to the US Constitution. For those history buffs who are listening, you know that that is the second of three Reconstruction amendments introduced after the Civil War. That amendment was ratified and adopted in 1868. So merely 5 years before the Coger case happened. And the court ruled for her. Next slide, please. In the Coger ruling, there was lots of remarks about the appropriateness of Ms. Coger's behavior, her attitude, or her conduct. And Justice Beck of the Iowa Supreme Court noted that her behavior was spirited resistance and defiant words, and her pertinacity in demanding the recognition of her rights and vindicating them, and said that she exhibited evidence of Anglo-Saxon blood that flows in her veins, but then goes on to say they don't need to consider what blood flows in her veins. They determined that irrelevant and rest on the 14th Amendment. Notably, Coger is role modeling what Pulitzer Prize winning historian Laurel Thatcher Ulrich wrote about in a 2007 book. Thatcher Ulrich said, well-behaved women seldom make history. And certainly Coger, by the definitions of the steamship company and other parties to that case, she certainly wasn't well-behaved. She was inappropriate, she was resistant, she fought, but she did make history. She made very important history in Iowa, and history that is certainly worthy of celebration here in Iowa. Let's put Coger in context going forward now. Let's move to the next slide. Oh, and skip one more. There we go. We're going to talk about civil rights legislation that closely followed the Coger ruling. Now, the U.S. Civil Rights Act was a federal law, not a state law, and we don't have documented evidence that says that that was prompted by the Coger case. But the U.S. Congress passed the U.S. Civil Rights Act of 1875, and that required all persons to be entitled to full and equal enjoyment of the accommodations and privileges of inns, public conveyances, theaters, etc., without regard to race. And in 1883, the US Supreme Court struck it down. And the basis for striking down that federal law is the 14th Amendment. We will come back again and again to the 14th Amendment. That is because the 14th Amendment, the very language of it, says no state shall make or enforce any law. It doesn't speak to federal legislation. It speaks to state law. And the US Supreme Court found that the Congress did not have the authority to pass the 1883 law, that it was unconstitutional because the 14th Amendment did not give Congress power to protect rights for individuals. It gave it to the states. Now in 1884, 140 years ago, and a mere 11 years after the court's ruling in Coger, the Iowa Civil Rights Act passed. That was in part a response to the declaration that the US Civil Rights Act was unconstitutional. It similarly mirrored the language in the US Civil Rights Act of 1875. It took them 9 years to get there, but they got close to the same language. And it was approved unanimously by the Iowa legislature. It also imposes criminal penalties on people who are violating the law. And it cites certain areas that are covered by the 1884 Act. Those areas are inns, restaurants, chop houses, which I haven't heard since I lived in Wisconsin, eating houses, lunch counters, and all other places where refreshments are served, public conveyances, barbershops, bathhouses, theaters, and all other places of amusement. And people cannot be excluded from the full and equal enjoyment of those places on the basis of their race or their ethnicity. Now, that laundry list in the Iowa Civil Rights Act of 1884 is really important to be mindful of, because from the passage of that law in 1884 until 1948, Iowa courts, for the most part, narrowly interpreted the statute to govern only those places specifically listed in the text of the law. So it's not as broad as it may seem on its face. The courts limited it, partly because of the punitive nature of the law, to only those specifically enumerated places. Let's move to the next slide. Out of the Iowa Civil Rights Act came a variety of cases that were implementing that law, that were brought under the Civil Rights Act and interpreted the Civil Rights Act. The first case that came out of that was, that we're talking about today, was Boland v. Lyon. And that's an 1885 case. So clearly in the 1880 somethings, cases moved much more quickly through the judicial branch than they do now. And we could learn from that, I think. But at any rate, Boland v. Lyon involved two Black men who were denied entry to a Cedar Rapids skating rink on account of their race. A case ensued, encouraged by the leadership of the African Methodist Episcopal Church in Cedar Rapids. And in the resulting case, the Iowa Supreme Court found that the owner's conduct, the skating rink's owner's conduct, did not violate any laws that were on the books at the time that the incident occurred. That is because although this case got to the Supreme Court in 1885, the incident occurred before the Civil Rights Act of 1884 was passed. So the court found that it did not violate any laws that were on the books at the time the incident occurred. And furthermore, the justices reasoned that the civil rights law was meant only to govern certain public spaces, not including skating rinks. So the court, that last bit of the law only governs certain things really wasn't before the court, because they're saying there's no action here for these two gentlemen who wanted to enter the skating rink, because this law didn't exist at the time they tried it. But the court did go on and say in its ruling in 1885, there was that the 1884 Civil Rights Act was meant only to govern certain public spaces, not including skating rinks. That's a first red flag, that this law is going to be construed very narrowly. Then we move to 1905, the Humbird v. Crawford case. And in this case, the plaintiff, Mr. Humbird, was one of the jurors to whom a civil cause had been submitted in 1904. Pending deliberations, the bailiff in charge of the courtroom arranged with defendants to serve dinner for the jurors. So defendants are feeding the jury, which is kind of interesting. And then that bailiff took the jurors to the defendant's home for dinner. Well, Mr. Humbird is a Black person. It's the only person of color on the jury. And upon arrival, the defendants refused to allow Mr. Humbird to sit at their table solely because of his color. They served the other jurors, but Mr. Humbird was compelled to go elsewhere for food. The court in this case asserts it is not questioned, but that this is a violation of the civil rights statute if, and this is an important if defendants were maintaining an eating house as such therein contemplated. So eating house is in one of those laundry list items within the law. And the court is saying, if this is an eating house, then the defendants have violated the law. And the court did find that eating house, that it was an eating house as defined by the civil rights law. I did not go find a definitional section, but I would be really interested in what eating house would be, given that this was a private home. It was not a restaurant or a diner or anything like that. It was someone's private home. Then we're going to look at the 1909 case, Brown v. J.H. Bell Company, which is applying again the 1884 Civil Rights Act. The Bell Company engaged in the selling of coffee in Des Moines and had a booth at what was called the Pure Food Show, to which the public was invited and an admission fee was charged. Defendant sold coffee to white food show patrons, but Brown, and it's actually Brown and Brown's wife, who are Black individuals, as the court describes it, the defendants, in a very rude and ungentlemanly manner, defendant failed to and refused to serve Bell or her husband for the express reason that plaintiff was a Negro or colored person. Now we're back to the Supreme Court's narrow construction. The court in this ruling specifically says the Iowa Civil Rights Act must be narrowly construed as it is a punitive law, which means that there are penalties with it, and held that although the Pure Food Show was open to the public, defendant's coffee booth constituted advertising by a private business and therefore did not violate the Civil Rights Act by refusing to serve people of color. So within the context of a public event, the court carved out and said, oh, this booth is a private business. It's advertising. And so they found no violation of the Civil Rights Act. They accepted that booth out of it. Lest you think that all of the history regarding the Civil Rights Act of 1884 is ancient, take a look at State of Iowa v. Katz, which is a 1949 case, also out of here in Des Moines. And on July 7th, 1884, Edna Griffin, an African-American who served in the Women's Army Corps at Fort Des Moines during World War II, her infant daughter and two African-American men were reserved refused service by a Cat's drugstore in Des Moines, Iowa, where she ordered an ice cream soda. She was with two other adults, her one-year-old daughter, and the store claimed they were not equipped to serve colored people. Apparently that aroused enough frustration and discontent in the public that the Polk County attorney filed charges against Katz for violation of the 1884 Act. Katz was found guilty and fined $50. And on December 13th, 1949, the Iowa Supreme Court unanimously affirmed the conviction, ruling Katz was charged with a crime under the statute, and there was evidence to show the policy defendant had was to refuse service to people of color, and that was admissible. Again, Edna Griffin is one of those not well-behaved women who did help make history. These cases continue, let's go to the next slide. These cases continue to reverberate through our jurisprudence here in the state of Iowa. There was a 2020 decision in Petro versus Palmer College of Chiropractic, in which Justice Apple wrote an opinion conferring in part and dissenting in part. And Justice Apple talked about the history of Iowa civil rights, writing in part, after all, although Iowa courts have often been remarkably advanced in the protection of civil rights, there have also been occasions where civil rights statutes have been narrowly construed to defeat their underlying purpose. And what did Justice Apple cite to? Coger as a victory, Clark v. Board of Directors, which we talked about earlier, also as a victory, but then pointed back to Brown v. Bell Company, the coffee dealers, as an instance when the Civil Rights Bill fell short. Now let's talk about some federal cases regarding civil rights. Plessy versus Ferguson comes out of Louisiana. It's not an Iowa case, but it is a stark contrast to Iowa's Coger case. Plessy versus Ferguson, which was decided in 1896, established the doctrine of separate but equal, which may be a familiar phrase to some of you. Louisiana law allows for common carriers to provide separate but equal accommodations for white and colored passengers. Mr. Plessy is 1/8 African American. He purchased a train ticket for white passengers and sat in the whites only car. The conductor of that train demanded that Plessy remove himself from the whites car and move to the car reserved for colored passengers. When Plessy refused, he was taken from the whites only car and arrested. Next slide, please. The court in Plessy versus Ferguson, the issue before the court is whether a state abridges the privileges and immunities of a person by allowing for separate but equal public accommodations. 23 years after Coger, the US Supreme Court held no. Constitutional guarantees apply only to legal equality, not social equality. So 23 years after Coger, separate but equal becomes the law of the land. In responding to the Supreme Court's ruling, Associate Supreme Court Justice Harlan wrote, "The judgment rendered this day will in time prove to be quite as pernicious as the decision made by this court," meaning the Supreme Court of the United States, in the Dred Scott case. The Dred Scott case predates Plessy by 39 years. In 1857, the US Supreme Court held that enslaved people are not citizens of the United States. Therefore, they could not expect protection from the federal government or from the courts. That's how Plessy came down. Next slide, please. The Plessy ruling remained the law of the land until 1954. In 1954, a young schoolgirl was the plaintiff in the case Brown versus Board of Education of Topeka, Kansas. 58 years after Plessy, the family of a little girl challenged the separate but equal standard. And US Supreme Court Chief Justice Earl Warren delivered the unanimous ruling that state-sanctioned segregation of public schools was a violation of what? What do we go back to? The 14th Amendment. That Reconstruction era amendment is still the foundation of the civil rights jurisprudence here. State-sanctioned segregation of public schools was a violation of the 14th Amendment and therefore unconstitutional. Warren wrote, "We conclude that in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal." So we've made progress now. We got to 1954. We've done away with the separate but equal. Now we're going to pivot back to Nebraska. Let's go to the next slide. Iowa Governor Harold E. Hughes proposed a Human Rights Commission in his 1964 inaugural address. And the 1965 Iowa Civil Rights Act was enacted by the 61st General Assembly. The 1965 Act, as amended, covers the areas of employment, housing, credit, public accommodation, education, and the retaliation for the exercise of civil rights. For example, if my boss here at the Civil Rights Commission says, well, you know, Jennifer, you're a single woman and, you know, you're over 40 years old. And so I just really don't have to pay you as much as I pay the colleague who sits in the booth next to you, who is a married father of 3 and has children to support. And I object to that. I challenge that. That's, and then I get fired. I get fired because I got mouthy. I was one of those not well-behaved women. And I speak out about that and I get fired. That's retaliation for the exercise of civil rights in employment. There's an example of that. The Iowa Civil Rights Act of 1965 created what is now known as the Iowa Civil Rights Commission, which is today tasked with screening and investigating complaints of discrimination based on the categories you see there. Categories have been added or tweaked over time, but those are the standing categories. When you see based upon familial status, that means maybe it's someone who has children, or maybe it's someone who is caring for an elderly parent with a disability. So that, yeah, I've got this great home that I renovated and I'm going to rent it because I bought a different house, but I want to rent to people with kids because they'll just trash the place. That's familial status. Or I only want to rent to people with 2 children. This person has 5 children. I think more than 2 children is excessive, and they're going to trash my house. So I'm not renting to them because they have 5 children. The commission, functioning as a neutral fact-finding agency, reviews complaints filed by Iowa citizens or people who are working or learning in Iowa We review approximately 1,800 civil rights and housing complaints each fiscal year. It varies a little bit, but it stays right in the neighborhood of 1,800 cases a year. We don't have a huge staff, but we work hard and we do our best to get things produced as promptly and equitably as possible. Employment discrimination complaints involving employers of 200 or more employees can be filed certainly with the Iowa Civil Rights Commission. We then cross-file with the Federal Equal Opportunity Employment Commission. And that may open up some additional rights and remedies for that employee. Housing discrimination cases involving federally financed housing or larger housing units can also be cross-filed with the U.S. Department of Housing and Urban Development. So we share jurisdiction with a couple of federal agencies, and we loop them in on some of our cases. Part of that is that then those federal agencies compensate the commission for managing those cases. Part of that strategy is clearing the dockets for the federal agencies, and part of it is that the commission is simply better resourced and better connected within the state of Iowa than a federal agency might be. So that is the Civil Rights Act and is the enabling legislation that created what is now known as the Iowa Civil Rights Commission. Next slide, please. Within the Iowa Civil Rights Commission, we've got a complaint process that is open to the public. We have online complaint forms, paper forms. Every day we have folks who are walking into our offices and saying, I have an issue, I have a complaint, can I ask somebody a question? And our staff are available to hear people out. We do not provide legal advice. We explain rights and remedies under the Iowa Civil Rights Act, but we do not provide legal advice. We do not represent parties in civil rights proceedings. We are a state agency. We are not counsel for parties. The Iowa Civil Rights Act, or complaint form, is long, and it's got lots of questions, and they don't always make sense to people. And I understand it's hard to fit all of the protected bases and all of the areas that we cover on a single form. Complainants can feel overwhelmed by that, and I understand that. Our goal is to get as much information as we can from folks so that we can give them the best resources we can going forward. It includes a narrative portion where people can tell their own stories in their own words. Sometimes people want to come in and talk to us and tell us their stories. Sometimes when I'm the person tapped to visit with a visitor to our office, I just make a quick outline summarizing the points that I'm hearing them convey to me. I will point out things that they might need to expand upon to help us understand better. And if they want to take my scribbled notes with them, that's fine with me. It's not part of the case record. It's simply a communication with a person here in Iowa who had a question. Once that complaint is filed, it is screened to make sure that we have jurisdiction for the case. And then it is evaluated to determine whether we think that there is a remedy available, that someone's rights have been violated and that there's a remedy available to them under the Civil Rights Act. If so, then there's further investigation that involves interviewing not only the complainant, but the respondents, the people who are being accused of acting in a discriminatory manner, and then an analysis is written after that investigation. It is never as quick as people would like it to be. We understand justice is slow and sometimes painful, but we certainly want to let Iowans have their say, to be heard by someone in their government and to respond in a meaningful way to that. It's a wonderful legacy to support the Iowa Civil Rights Commission on the sesquicentennial year of the Coger case, and it has been a true privilege to speak with you folks. Thank you so much.
Well, thank you, Jennifer, for putting that into bigger context of the timeline of Iowa history too, and hopefully we've given folks a framework of how Coger fit into Iowa judicial rulings and civil rights legislation. So with that, we'll turn it over to the next set of programs. But thanks to everybody for tuning in today.
Thank you, Jennifer and Leo. That was some hard history and can make us proud of Emma Coger and the Iowa judiciary. We have time to answer some questions. If you have a question, please submit it through the Q&A feature on Zoom. A few have been sent already, and we appreciate that. Please note that we may not be able to get to all of the questions. To begin, what was the meaning of the word packet? And Jennifer or Leo, could you describe a little bit more about what the dining arrangements were like on a packet?
Jennifer, you don't mind, I'll jump in on that one. And if you want to elaborate, you can too. But packet is one of those words that we don't use commonly today, but it meant a steamboat. And so when you talked about a packet, that was the steamboat traveling up and down the Mississippi River or the Missouri River on the Iowa border to the west. And in the 1870s, when the Emma Coger, again, 19-year-old young woman, is on that, it's one of the main transportation methods for the people of Iowa, that and railroads. And so the idea that there were different places where, depending on what you had purchased, you would be forced to dine. And if you hadn't purchased a ticket in the main dining area, and Emma Coger had purchased her dining ticket, you might be eating out on the outside deck along a rail, maybe standing up, or maybe there would have been a table for you or some very simple chairs. But the main dining accommodations on a steamboat along the Mississippi River from Keokuk up to Lansing and farther north were really fine dining experiences in many of these cases. And so Emma Coger was just seeking to dine with the rest of passengers in the primary dining area. So understanding that context, that she wanted her rights and was seeking what was available to anyone else, and willing to pay the money for it, was something that most people, any white person, didn't consider an issue, and so she didn't. And so understanding those different types of accommodations that would have been were trying to be forced upon her were just in our perspective outlandish, but for many Blacks in Iowa and across the nation were being treated as second-class citizens, and she wasn't going to stand for it.
Thank you, Leo. Next question is, was Iowa a pace setter among states with the Iowa Civil Rights Act? And how many other states were passing similar state laws?
This is Jennifer. I did not research when other states had passed their civil rights acts. So I can't specifically speak to that. In some ways, Iowa was considered progressive, but it took a while to get there, frankly. And they worked pretty promptly, given that the Iowa Civil Rights Act, its first one, was passed just briefly after the passage of the 14th Amendment and the failure of the federal law. That does show some leadership among the Iowa legislature.
Well, thank you, Jennifer. And then another audience question that just came in, and one that is especially interesting as we look at the through lines of history. What became of Ms. Coger? Did she stay in Iowa or move on eventually?
I
know a little bit about, I've looked at her. Again, keep in mind, she's living in Quincy. I can't recall if she had ever been enslaved. I believe she was. I believe her parents had been enslaved in Missouri, and then either shortly before the Civil War or during the Civil War, gained her freedom, had been trained in school. There's some good websites that we'll make sure to give to Matt and Jess to share out on her life afterwards. But I believe she finishes her life in Illinois through the rest of her lifetime. I believe, continuing to be a teacher, but we'll make sure we get that in the resources we share out. And anything you want to add, Jennifer, that you know about her?
Nope, I have nothing to add. Thank you.
Okay. Thank you. And then what is the overall importance of the Coger case for Iowa's civil rights protections?
Well, I can jump in just from my perspective, and I know Jennifer will have some thoughts too. But as Jennifer related, you know, there still continued to be efforts at discrimination. I think of the Brown versus J.H. Bell case that she referenced in Des Moines. You know, that's S. Joe Brown and Sue Brown, and as Jennifer mentioned, you've got one of the premier Black lawyers of Iowa, S. Joe Brown, he and his wife being discriminated against at an event in Des Moines. You know, the Coger case goes back to 1873. You've got the Civil Rights Act of 1884, and yet Blacks in many cases in Iowa were being treated as second-class citizens still. And you think about Katz, but there are other cases. Charles and Ann Toney of Davenport, a Black couple who in 1943 had gone to an ice cream shop and were denied service because of their race there. The case was settled in 1945 in the Toney's favor. There's a good Annals of Iowa article on that case, our state history journal. And I even think of, you know, at the same time, 1944, Archie and Audra Alexander, Archie having been a University of Iowa football player who gets a civil engineering degree in the early 1900s, early teens. There's a restrictive covenant on a house in the Chautauqua Park area, just off Hickman Road in central Iowa, near Broadlands Hospital. Nice neighborhood, but the Alexanders are told by a neighborhood group, oh, you can't purchase that house in 1944 because there's a restrictive covenant saying they will not sell, that house cannot be sold to a Black couple. James B. Morris, Des Moines lawyer, again, Black man, one of the more prominent Black lawyers and an important figure in national and Iowa history, is their lawyer in that case. And you have, you know, again, Blacks being told something can't be done right. So important to recall, you know, people like Emma Coger and advocating for their equality. Our state doesn't always live up to the ideals that we wish it would. And it's when Black Iowans refuse to be treated as second-class citizens, as Jennifer said, whether it be Edna Griffin, petitioning and picketing with others outside of Katz drugstore, that change typically happens.
It seems to me one of the things that's really noteworthy about the court's decision in Coger is that it specifically determined that whether white blood predominated in her veins was irrelevant. And that ties very closely with some of the modern Iowa civil rights complaints that we get in this office on a regular basis, where people are being discriminated against. They may be Colombian, but they're being told they're Mexican and they're stupid and their hair is greasy and their tacos have cat food in them. And so it's that the court, I would argue, in Coger is acknowledging that even if you're being discriminated against on the perception of a race, that is unconstitutional. And I think that is a really powerful legacy of Coger. We're not doing blood tests or genetic genealogy or anything like that. If someone says, people perceive me as fill in the blank, that is the perception. And if they're being discriminated against on the basis of that racial perception, then that may well be an actionable case, even now in modern day Iowa jurisprudence. And I think that's really powerful. I think one of the other things that is noteworthy is Emma's age. And at that point, she would not have been perceived as an adult necessarily even. And I'm sure Leo can speak more specifically to that, but it is showing the accessibility to the courts, at least on some level, by folks who may not have access necessarily elsewhere. And that is a powerful legacy, not only for civil rights, but for access to justice in Iowa.
Thank you, Jennifer. And that's a great lead into the next question. I was wondering if you could discuss a little bit more. What were the risks to 19-year-old Emma Coger for filing a lawsuit like this?
Well, I'm sure Leo has lots of thoughts on that. I certainly there are still then and still now there are different schools of thought on whether it behooves you to be well behaved or it's worth speaking up and taking a risk. Certainly, there's a possibility that Emma Coger could have lost her job, could have been ostracized by her community, could have faced, frankly, physical risk. I mean, she was dragged out of a dining room, and you know the steamboat staff said they used as much force as necessary. So there were physical dangers, but there were also potentially social risks and financial risks to her as well.
And thanks, Jennifer. And just to frame it a little bit more on a national and maybe statewide level too, you know, in the period of statehood, we don't know, and I'm still always looking, and no other historians are, for instances where there have been any physical lynchings in the state period of Iowa. And I haven't seen any lynchings in the state of Iowa in the post-1846 era. There was a tragic case in the territorial period, and just as a warning, going to talk about some pretty awful events right here. So, you know, give me till about 12:58 if you've got a timer to tune back in. If you don't want to hear some awful stories about racial abuse, but there was a man in Dubuque, Nathaniel Morgan, in 1840. And here's where I'll get a little, you know, descriptive, but the story in the newspapers was that he had been accused of stealing some things in Dubuque. He was a well-known figure, had been kind of a porter and a handyman around Dubuque in the territorial period. He was accused of stealing things, and it was described that he was stripped of his shirt and lashed 300 times. And when he wouldn't confess to having stolen things, he was continued to be beaten. He then confessed to doing something. They couldn't find what he had confessed to. He was then died from being beaten eventually a day or two later. Sorry, I don't have the specifics there. But that is the one instance where we know in Iowa history, a black man was beaten to death for a crime he did not commit. So he wasn't taken out of a jail and hung. He was beaten to death, and that's no better and perhaps worse than the other option. And then again, still talking about some hard history here. So if you jump back in, just we'll quickly reference a Indiana case along the Ohio River where George Johnson, Squire Taylor, Charles Davis on November 17th, early in the morning, they'd been imprisoned for allegedly killing a white family. A mob took them out of the prison there along the Ohio River outside of Charlestown, Indiana, and they were hung in the woods and, at least by some accounts, mutilated by fire. So just some awful stories. And I don't want to end with those stories. So hopefully we can get one more question in, Jess.
Well, I think it's a good idea to not end on those as well, Leo. So just probably one more question. And I was wondering if, Leo, do you or Jennifer know if there are any memorials to Emma Coger in either Iowa or Illinois?
I'm not aware of one, but we have a great state historic marker program. So either in, and I've talked to the Iowa folks at the Iowa Judicial Branch, are keen on this. And so both Jennifer and I had talked about there's a really great display on her at the Iowa Judicial Branch building here in Des Moines. She's part of the civil rights history on the first floor. You do have to navigate through their security system at the Judicial Branch, but would encourage people to explore our Judicial Branch building and maybe see the Shattering Silence Memorial on the Judicial Branch grounds connected to the case of Ralph. And if someone in Eastern Iowa wanted to do a historical marker, our colleague here at the State Historical Society of Iowa, Mike Plummer, runs our State Historical Marker Program. And I'll be quiet, Jennifer, in case you want to put in like a 30-second comment too.
I would commend to people the Des Moines History Walking Tour, which I don't know that it would have a Coger memorial included, but it's got some really interesting highlights and allows you to explore events that did happen here in Iowa. Some of them connected to civil rights and other momentous events. But so the Des Moines History Walking Tour is a neat opportunity, especially before it snows here.
Thank you, Jennifer. That's a great suggestion. And with that answer, we will bring this webinar to a close. Thank you to everyone joining us today, and we would like to extend one last thank you to our presenters. We hope everyone will sign up for the Iowa History 101 webinars that take place on the 2nd and 4th Thursdays throughout the year. There are many great stories to tell in the upcoming months. For more information and to register for future webinars in this series or to watch recordings, check out our website at history.iowa.gov. While you are there, you can look into some of our other fantastic digital programs, such as the Goldie's Kids Club activities for young historians. We look forward to virtually seeing you for the next Iowa History 101 webinar on November 9th. Thank you for joining us today and have a great afternoon.